Attention, you shall pay the United States, the great state of Florida, and this honorable court.
Please be seated. This morning, we are down to one case on the calendar, Holmes versus Parrish. If counsel is ready, you may proceed.
Good morning. May it please the court. I am Bill Horgan. This is my partner, Mark Tinker. We represent Robert and Yvonne Holmes. I'll be reserving 3 minutes for rebuttal today. The issue, as the court is aware, is whether our client's insurer, Allstate, reached a settlement agreement with the appellee, Amanda Parrish, who had a personal injury claim against the Holmeses. Since we're dealing with an issue of pure contractual construction here, purely of contract law, standard of review is de novo. I know the court is familiar with the facts in terms of which letters went back and forth and who said what when. So I'm going to forego talking about that this morning in order to conserve my limited time. As you know, the trial court denied our client's motion to enforce the settlement agreement, and it told us why in its order. Paraphrasing, just slightly, this is what the court said. Quote, "The indemnity requirement contained in Allstate's response to Parrish's demand introduced a new term and thus constituted a counteroffer." And the trial court relied on a 4th District opinion called Grant. Now we have a case called Gonzalez. Pardon me? We have a case called Gonzalez versus Claywell. Indeed. And seems like it's pretty close to what we have here. How would you distinguish it? I will answer that in just a second. In Gonzalez, the reason that there was no settlement agreement was because Geico tried to add itself to the release after the plaintiff specifically offered to settle and only release the tortfeasor. That's why. Because Geico insisted upon it. The plaintiff said, hey, look, I will release the tortfeasor, send me a release. Geico sent a release back that would purport to release not only the tortfeasor, but also Geico itself. And so the offer and the acceptance did not match. There's no mirror image. Geico insisted on something that the plaintiff had never offered to provide. That's why. That didn't happen here. And the point that I'm ultimately getting to is that when you consider the trial court's ruling, which was that the indemnity requirement, that was the court's words, contained in the correspondence constituted a counteroffer. In fact, it did not, because there was no indemnity requirement. Just as if Geico had never bothered to put itself in the release at all. There is no indemnity requirement in the things that Allstate sent back, not in the release and not in the correspondence. And that's really the question. The real question here is, did anything Allstate did when it sent back the letters purport to impose a new obligation on Parrish? On Parrish. After all, Parrish was the party that Allstate was settling with. We're not talking about Parrish's lawyer. We're not talking about Parrish's lawyer. And as I'll explain later, that means that if Allstate made statements about separate legal duties of Parrish's lawyer, be they correct or incorrect statements, that is not an attempt by Allstate to impose a new obligation on Parrish. Now, there were 3 sort of topics that found their way into the briefs. The first was the release, then there was the language in the correspondence, and the third was the affidavit about insurance coverage. Unfortunately, I don't think I'll have time to get to all of those today, so I'm just going to really concentrate on the first 2, and I'll address the release briefly because I think it becomes important when you get down to the real crux of the matter, which is the language that was in the correspondence. The release, in my view, is pretty clear. Even though it's accurate, it's true that Allstate's release had indemnity language in it. Allstate told Parrish 9 ways to Sunday that Parrish should modify the release or even discard it and use one of her own in order to satisfy her conditions about indemnity language, about omitting indemnity language. In fact, it looks like, by my count, Allstate, maybe 4 ways to Sunday would be a better way to think of it, because it looks like Allstate told Parrish this 4 times. Allstate told Parrish to change the release to match paragraph 3 of her offer. Paragraph 3 was the condition about the release not having any indemnity. So Allstate said right off the bat, go ahead and take that out. We understand. We know that that's one of your conditions and you don't want it in there. We're just providing you this form release. Take the indemnity language out. Allstate also told Parrish that she could use an entirely different release if she wanted to. It wasn't wed to this release. It wasn't wed to the language that was in it. Allstate also told Parrish that she should just send back any changes she wanted to make, and that she should let Allstate know if she modified the release. Common sense. All right, let us know if you change it. You're free to do so. So as far as the release is concerned, that is not an example of Allstate attempting to impose an additional indemnity obligation upon Parrish. They clearly told her, we're not wed to this language. We know what it is that you want. Take it out. Use a different release. We understand. Okay? No attempt to impose an additional obligation. And that's really what makes most of the cases that Parrish cites different. It makes them distinguishable, because in most of those cases, insurers were demanding certain things in releases, wouldn't retract them, were insisting upon them, and so that's why the mirror image rule was not satisfied.
But I'm having a hard time getting to the point where I can say that they agreed to the same terms and thereby formed a contract. It seemed like, at what point in time were they all in agreement?
That's a good question. And that is something that I think none of the briefs really addressed very closely. And here's the answer. The answer is that because Parrish's offer required acceptance by performance, right? A return promise wasn't good enough. Parrish's offer said, you need to perform. There's 4 things you need to do. You need to, I'll sign a release, but it's got to have certain language in it. You need to send me an insurance affidavit. You need to send me the entire limits of your policy. You need to make the check out a certain way. Performance was required in order to accept. But here's the law about precisely when acceptance happens, when an offer calls for performance. When an offer calls for acceptance by performance, acceptance is deemed to exist when performance begins, not when it ends. Not when all 4 of the things are accomplished, but instead when Allstate begins to accomplish the 4 things. And if you think about it, that makes a lot of sense. Because if my neighbor tells me, I will sell you my car if you give me $10 and you walk to the Golden Gate Bridge. I give him the $10, I start walking. I've manifested my intent to accept. He knows my objective external signs, which are all that the court must measure, show, hey, Mr. Horgan is accepting this offer, because there he goes. And that's when the acceptance begins. And what it does in a couple things. I mean, primarily, though, it stops people from retracting once I've already walked to Utah. And so that's when the acceptance occurs, when performance began. And what happened here is Parrish sends her offer over. And her offer's got 4 pieces in it, right? The 4 that I just mentioned. And then Allstate writes back. I think the date was February 25th, 2008. And says, okay, I understand. And here I go. I'm going to get started responding and satisfying your conditions. Here's a release, or one is coming to you shortly. It's going to be made out the way you want it to be made out. Here's a check. And I will send you the insurance affidavit eventually. Well, actually what they said was, is this good enough for an insurance affidavit? But when that happened, when Allstate responded to say, I understand your conditions and I am starting now to satisfy them, that's when the acceptance happened.
Well, I understand your position is that Allstate said, we don't care about the release. You can write whatever release you want.
Right.
Well, arguably there would have been some kind of release they could have sent back that Allstate would have said, whoa, wait a second. Right?
I suppose, arguably, that could happen, but it didn't happen here. So, in my view, we're not concerned with it. Now, I want to take a brief minute to address the language that's in Allstate's letter to Parrish's counsel, because that seemed to be really what the trial court was hinging its determination on. Okay? Now, the language, paraphrasing it, said that Parrish had a legal, that Parrish's counsel had a legal duty to satisfy valid liens, that Allstate was relying on this to happen, and that Allstate wanted indemnity from Parrish's counsel if it didn't happen. And I think it's important here to define the precise question that this court is answering. The question here is whether that statement to Parrish's counsel was an attempt by Allstate to add an additional obligation upon Parrish. upon Parrish, and it was not. And there are really two main reasons for that, though I think they sort of end up coalescing kind of into one. The first reason is that this letter and that statement was addressed to Parrish's counsel. That's who it's sent to. And that is who Allstate believed had this obligation. It is not a part of the settlement agreement with Parrish. Instead, it's just a statement about what Allstate believed Parrish's counsel's responsibility to be when handling this claim. Over here, on the one hand, we have the agreement between Allstate and Parrish. Allstate will pay the limits. Allstate will make the check out a certain way. Allstate will give an insurance affidavit, and Parrish will sign a release. Over here, we have Allstate's statement that Parrish's counsel has to satisfy the liens. That statement doesn't have any effect on the agreement with Parrish herself. It doesn't add an additional term to that agreement, and that's the question for the court today. As I said, it's only, in my view, a statement about what Allstate believed Parrish's counsel's duty to be when handling this personal injury claim. And there's a difference between the terms of the substantive settlement, which is the question here before the court, and the duties of the plaintiff's lawyer when administratively putting it all together. Now, I felt like the briefs, ours included, sort of, the more I've thought about it, I think they kind of got off base a little bit when they started arguing about whether or not Allstate's statement was true, whether it was true that the plaintiff's counsel had an obligation to satisfy the valid liens. Now, I think it is true. I think that a plaintiff's lawyer does have that obligation. If it's true, that's certainly positive for Holmes, because then it could not have added a new obligation that the law didn't give elsewhere anyway. But I also think that it doesn't really matter whether it is true or not, because it's not an obligation upon Parrish. Suppose that Allstate had said, okay, here's the letter. We understand your terms and conditions, and we're going to be sending you a check. And by the way, Parrish's counsel, you have an obligation not to embezzle these settlement funds. That'd be true. And it wouldn't have anything to do with whether or not an agreement was reached between Allstate and Parrish. On the other hand, let's suppose that Allstate had said, okay, here you go, Parrish's counsel. Here's the release, insurance affidavit information. And by the way, Parrish's counsel, you have a duty to wear a purple shirt to work on Friday. That would have been false. But it also doesn't tell us whether or not there is an agreement between Allstate and Parrish. Now, I was hoping that I would have a chance to get down to the issue about the insurance affidavit. I'd still like to discuss it, but I think the point is clear enough that not providing the insurance affidavit is irrelevant here, because acceptance of the offer is effective when performance began. The fact that it ultimately never gets provided doesn't affect whether or not there is actually acceptance here. That's all for now. I thank the court.
Thank you.
May it please the court. My name is George T. Reeves, represent the injured party in this case. Under this court's opinions in Hansen versus Maxwell, to create a binding settlement contract, the acceptance has to be absolute, unconditional, and identical with the terms of the offer. Further, it is not what the parties intended, but rather it is not that they having meant the same thing, but on their having said the same thing. In this case, they did not say the same thing. There were three parts to the settlement agreement. They had to give my client a check, which they did, everybody agrees. They then had to provide a release with no indemnity and hold harmless. They then had to provide an affidavit. There's no document in this record called an affidavit. Not one. No document that satisfies the requirement of an affidavit. At this point, we're done. There's no settlement agreement. That's something they cannot get around. The next, on the release part of it, we specifically said we wanted a release with no indemnity, no hold harmless. They sent us a release with indemnity and with a hold harmless. They did send one letter. That one letter said, you may change it to match the requirements of your letter in paragraph 3 or whatever the paragraph was. That letter probably would have gotten us real close to an acceptance.
Why didn't you change it back to the way you wanted it?
Why trial counsel didn't was because there was also another letter that was sent at the same time One letter accompanied the check, the one that said change it. The other letter accompanied the release. The letter accompanying the release did not say, absolutely, you may change this to match paragraph 3. The other letter said, if you want to change it, call us and we'll talk about it, or words to that effect. It was not an acceptance. It was, in fact, a counteroffer based upon that other letter. Now, they've got 2 letters. One is pretty close to an acceptance. One is definitely not an acceptance because it says, if you don't like it, call us, we'll talk about it. That does not satisfy their burden. Of course, it is their burden as the ones pushing forth the settlement, that their acceptance is absolute, unconditional, and identical. It cannot, because there are 2 conflicting letters that were sent at the same time. If one of those letters is supposed to have priority, we assert that it's the one that accompanied the release. That's the one that said, if you don't like some of these terms, call us and we'll talk about it. It did not say you have the absolute right to change this. The next part of it, though, with that letter that accompanied the release, it added a term, and what we feel is adding a term to the deal. And that term is, counsel, you have an obligation to indemnify us. That was never part of it. That was not an absolute, unconditional, identical acceptance. That's adding something to it. Now, they came back at trial and said, oh, by the way, we're just reciting what the law is. Okay? Their attorney said, Mr. Diamant, this is a carefully drafted form letter from Allstate. This isn't something some adjuster ran off his typewriter. It's a carefully drafted form letter. Certainly a carefully drafted form letter could add a sentence that says, we do not intend to impose any other requirements other than those required by law, that kind of thing. But they didn't. They put in there a term. When pressed on the issue, they could not provide a case that said there is a generalized duty of a lawyer to indemnify the insurance company. They could not do that. Of course, there are certain instances where that applies, such as Medicaid and those statutes that are in the briefs. But there's no generalized duty for that. They could not provide that. Now they're coming in and saying that, well, but we just meant that we thought the law was that way. That's what we meant. But again, under Hansen versus Maxwell, it's not about what they meant. It's about the parties having said the same thing. In this case, we didn't say the same thing. And so there's no settlement agreement reached. Further, I want to point out the final provision in the reply brief invites the court to do something. The final provision says, the final paragraph, I believe, in the reply brief says, it specifically concerns the affidavit. It says if you find the affidavit, that we didn't meet the affidavit requirement, please go ahead and rule that what this was not a counteroffer, this was an inquiry, or find that they withdrew the offer too quickly, or words to that effect. We would request the court not do anything like that. The whole point of that is, and it's plain from the record in this case, that there's an issue of bad faith. There's a settlement agreement reached, and that's in the record. The point of that was to ask the court to do something that is beyond what's before the court today. What's before the court today was there was an offer. Everybody agrees there was an offer. Was there an acceptance? If the court finds there was not an absolute, unconditional, identical acceptance, the court's done here today. Those issues about whether there was a counteroffer, whether or not that we withdrew the offer, whether anybody acted in good faith, all of that, that's for a later day and should be decided by a jury in a trial court and then ultimately by a different panel on appeal from that case. So we would request that the court strictly limit it to what's before it today, which is, did they absolutely, unconditionally, and identically accept our offer to settle the case? And again, we would point out, regardless of Mr. Horgan's best efforts, it's not about what people meant. It's about whether or not they said the same thing in their documents going back and forth. In this case, they clearly did not say the same thing, and the trial court's order denying enforcement of the settlement should be affirmed. So unless there's any questions, I'll go ahead and stop. Thank you.
Thank you.
I'll be very brief, I think. Mr. Reeves is correct that the parties have to say the same thing. The place where they said the same thing was when Allstate wrote the letters back and said, we accept, we understand, we are setting about now to satisfy your 4 conditions. That's where the saying the same thing happens. And so long as no additional obligation is inserted there, and we feel there was not, parties said the same thing. The acceptance is correct, and the acceptance existed, and the agreement existed, and the trial court should have granted our motion. So that's what we asked the court to do. Thank you. Unless there's any other questions? I appreciate the court's time today. Thank you.
Thank you, counsel. Thank you both. That concludes our calendar for this morning. The court is adjourned.